Good morning. Happy Sunday.
What's up, Playboy? Okay, guys, this is how you serve a federal civil rights lawsuit right here.
What's up, Playboy? He was not able to serve a federal civil rights lawsuit. So this is Lofty versus Holman, Smith, and City of Forney, and these are the proofs of service that he filed. Now, serving a summons and complaint is governed in federal court, is governed by Rule 4 of the Rules of Civil Procedure. It lays out how you do it. You can request waiver of service, which is the way usually you would want to do it, especially if you're dealing with a sophisticated litigant like the city of Forney and police officers. They get sued all the time. They're sophisticated. They know what to do. They're not going to duck service. It's easier and faster if you just request a waiver. Otherwise, it's individuals are served according to state law. That's a foreign country. So state law, you can serve them by whatever form of service of summons is accepted in the state, or basic kinds of service. You hand it to them personally, you leave it at their residence where they live, or you give it to an agent who's authorized by service. With a corporation like a city, it's under H. Here we go. Same thing as above. The other big one is, generally speaking, cities have an agent for service of process. It's designated in their city charter or whatever founding documents. And normally you can determine who that person is just simply by calling them up and saying, "Hey, I've got to serve a lawsuit on the city," and they'll be like, "Okay, here's who you serve." Right? It's not hard. I've served process many times myself, for whatever reason that we didn't want to hire someone to serve process for us. It's pretty fast and simple and easy. So you can see how he screwed up. First of all, he has multiple check marks, lowercase d in his name. I think that's hilarious. Apparently, the other attorney also thought it was hilarious. So this is for David Holman. So did he personally serve David Holman? No. In the video, he did not. Uh, Tamara, I think this is supposed to be Osborne, but his spelling is atrocious. He didn't check the box, so we can ignore that. But he did check the box that he personally served the cop at Forney PD, but he didn't actually give the address or the date of service. And then he also checked a box that he served this process upon blank for this defendant at his last known place of employment. That's not a thing you can do. You can't really serve substitute service for somebody at their last known place of employment. So that's kind of weird and wrong. And then, of course, he didn't charge anything for it. Yeah, he put numbers in, but he didn't charge anything for it. So I'm not going to worry too much about that. The same thing with Corporal Smith, except this time he actually also checked the box that he left it with Tamara O'Soni, but he didn't put a date, no date. And then this one, he didn't say who he left it with, and also there's no date. At least he managed to capitalize his last name there. It's so weird. A dude forgets to capitalize his last name. And then finally, this is for the city of Forney. He personally served the summons on the individual, Megan Killingsworth, who's an executive assistant. So see, he had to write with there because you, if you're going to check the box, I serve the individual, then you're actually serving the individual. The city of Forney is a corporation, not an individual. And so you can't serve the individual. You have to serve the agent for the city. So he checked the wrong box and he didn't put a date in. Cities don't have residences or usual places of abode, so that's a dumb box to check. This is the box he should have checked. I served the summons on, and then he should have written the name of the person who is designated by law to accept process of service on behalf of the city of Forney right here, and he should have put a date here. Now, I know people are going to say, but he put a date here, but he put a date here. This is the date that he's saying that he's signing the declaration under penalty of perjury. That's all that is. He's not saying that he did the service on that date. He's saying that he signed the declaration under penalty of perjury on that date. So words are important, especially when you're in the legal profession. Words on a declaration under penalty of perjury, they mean what they say and they say what they mean. And he did not put any dates for service anywhere in here, which has prompted, well, so normally, I think what would normally happen, especially with a sophisticated litigant who doesn't want to waste a lot of money on motions just to, you know, kind of be a dick about things, is normally you just, okay, fine. You file your answer, you get going, right? Because it's going to happen. Let's not waste extra time and money. But that's not what happened in this case. So here's this is the motion to dismiss that the attorney filed for them. The pro se plaintiff has sued two City of Forney police officers, Holman and Smith, along with the City of Forney, arising from a road rage incident between plaintiff and another driver occurring November 10th, 2021. These Forney defendants have been ensnared in this litigation due to plaintiff disagreeing with the officer's investigation of such incident and the brief detention of plaintiff at the scene. In his complaint, plaintiff decries alleged anti-Muslim sentiment from Officer Holman, although the entire incident was recorded on video debunking same. Leaving his spurious allegations aside, the plaintiff's threshold problem is more glaring. Neither he nor his internet self-promoting custodian of the court, Jose Small D DeCastro, have properly served any of these defendants. The fatally flawed service of these summons in a civil action is not only evidenced by even a cursory review of the proof of service, but further underscored by the very video posted online crowing about purported, but clearly defective, service. A copy of such video is attached hereto as Exhibit Number 1. Through the botched handiwork of plaintiff's cohort, custodian of the court, Small D DeCastro, the summons were simply dumped with administrative employees in the City of Forney manager's office and a technician at the Forney Police Department. Specifically, the summons were merely dropped off with Megan Killingsworth. By the way, he misspelled Megan Killingsworth. He spelled it Meagan, and it is Megan. The executive assistant to the Forney city manager, and Tamara Osborne, which he spelled as Ozone, Osone, a records technician in the police department, neither of whom were authorized to accept federal summons, have it in their job description to do so, nor are they statutorily designated as a proper person for service on a governmental entity. Indisputably, none of these summons were properly served on any individual defendant or a proper representative for the City of Forney. Nor did anyone agree to accept service on behalf of any of the defendants. The court should quash the purported service and dismiss without prejudice all claims against these defendants. So he's seeking a 12b-5 dismissal. It is a dismissal without prejudice. And he goes through it. Well, we'll do it. Plaintiff purports to have served the Forney defendants. Plaintiff, through putative process server lowercase d DeCastro, just dumped the summons with administrative employees working for the City of Forney. As previously discussed above and described more fully below, plaintiff service of these summons is wholly insufficient. Federal Rules of Civil Procedure 4 establishes the procedure for effectuating valid service of process. To effect proper service, blah, blah, blah. We've gone through it. The federal rules do not permit service by leaving documents at a place of business nor at City Hall. However, Rule 4E1 permits a party to follow state law for serving a summons. Under Texas Rules of Civil Procedure, a plaintiff may serve defense either by delivering to the defendant in person a copy of the citation showing the delivery date and a petition, or mailing the defendants by registered or certified mail, return receipt requested, a true copy of the citation with a copy of the petition attached thereto. So what he's saying is, under the Texas Rules of Civil Procedure, all DeCastro had to do was mail everything by certified mail or registered mail, return receipt requested. Ugh, Jesus Christ. But he got to make a video about it, right? Here, plaintiff's YouTube colluder, lowercase d decastro, did none of this. Instead, he doctored the form proof of service to try to contort his actions into valid service upon the foreign defendants, and in the process has now sworn to this court under penalty of perjury that he did so. The sophomoric and theatrical attempts playing to an internet crowd do not constitute proper service under the federal or Texas rules of civil procedure. Due to this inadequacy, respectfully, this court lacks personal jurisdiction over these defendants who have not yet been properly served. Accordingly, defendants respectfully request that the court dismiss the plaintiff's claims, or in the alternative, order the plaintiff to properly and timely effectuate service of process as to each particular defendant. So I have a sneaking suspicion that the court will just order the plaintiff to properly and timely effectuate service of process. That tends to be what they do. They don't want to make Mr. Lofty pay an additional $400 and change to refile the petition and to go from there. But yeah. So apparently Robert J. Davis was not too thrilled with DeCastro's shenanigans. And so there we go. You know, Chillie isn't really helping the people he thinks he's helping. I just want to point that out. He's not helping the people he thinks he's helping. Thanks for watching. Have a great day.